At this time, we will call the July 20th, 2026 meeting of the East Hempfield Township Zoning Hearing Board to order. Members of the board who are present this evening are Mr. Kyle, Mr. Caldas, and myself, Mark Hanson, Chairman to the board. Also for the record, we have Mr. Mans, our zoning officer to the township, and our legal counsel, attorney Jason Hess as well. We also have a court reporter with us. Scheduled for this evening under old business is case number 2499 for the decision, and any other business may come before us this evening. Because there is no testimony tonight, I will not be giving the oath or affirmation. Any person having an interest in tonight's decision will be given an opportunity to ask questions after the decision is made. At this time, we all stand and salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Just a reminder, if anybody speaks tonight, please use one of the mics because this meeting is also on Zoom. Jeremy, has the case this evening been posted and advertised in accordance with the Sunshine Law and the ordinance?
Yes, it has.
Gentlemen, you have received a copy of the June 15th, 2026 board minutes as presented by our secretary. If there are no deletions, additions, or corrections, I ask for a motion to approve the board minutes as submitted.
So moved.
Do I have a second?
Second.
Motion by Mr. Kyle, second by Mr. Kalash to approve the minutes. Mr. Kalash, how you vote?
In favor.
Mr. Kyle?
In favor.
And I will also vote in favor. Minutes have been passed. Jeremy, any old business?
Yes, case number 2499, CNH Plus Materials, 929 Quarry Road, seeking a 400-foot setback variance for a quarry use and the timing requirements to act on the zoning hearing board's decision.
Okay. Prior to our solicitor making comments on the decision that the board will be making at this meeting, I want to address the high volume of mail that the township has received on this application addressed to the zoning hearing board following the conclusion of the hearing on June 15th. At the outset of the hearing on June 15th, the township zoning officer attested to the fact that he gave the notice that is required under the municipality's planning code and the township zoning ordinance, meaning advertising the hearing twice in a newspaper of general circulation, which the township does in LNP, and posting the property that is subject to the application. At the conclusion of the hearing, the board closed testimony and approved a motion to take the allowable 45 days to render a decision, which it is permitted to do. Following the close of the hearing, the township received letters from the Bent Creek Property Owners Association and individual property owners. The municipality's planning code under section 908 parentheses 8 prohibits the board from taking notice of any communication, reports, staff memoranda, and any other materials except advice from their solicitor unless the parties are afforded an opportunity to contest the material so noticed. As the hearing had already been closed, the parties do not have an opportunity to contest the materials. The board was aware of this requirement and reminded of such by our solicitor. Consequently, the board did not take notice of any letters received and has not considered any of their contents in the decision it will be making. At this point, I'll turn it over to our solicitor, Mr. Hess.
All right, thank you. As stated by the chairman, the hearing in this matter occurred on June 15th. The parties to the proceeding were the applicant, who was represented by attorney Kurt Williams, and protestant Matthew Elliott, who was represented by attorney Melvin Newcomer. The township, which is a party to all zoning hearing board cases, did not actively participate in the hearing. Under section 9089 of the municipality's planning code, the board shall render a decision within 45 days after the last hearing in the matter. Testimony was closed on June 15th, 2026, and the board announced it would render its decision at tonight's meeting, which is within the required 45 days. Under Pennsylvania law, the board is considered a quasi-judiciary agency, whose decisions are subject to appeal in accordance with the municipality's planning code. Therefore, the board is permitted to deliberate and confer with counsel outside of the public meeting. Consistent with our practice, I spoke individually with each board member following the conclusion of the meeting and discussed any legal questions they had, as well as how they intended to vote on the application. Based on those discussions, I was able to draft a written decision containing findings of fact and conclusions of law for the board's vote at this meeting. The board still needs to formally vote on whether to approve or deny the application, and if it approves the application, what conditions to place on the approval. With that being said, I'll ask the board if there is a motion on the application presented by CH&M Materials in case number 2499.
Gentlemen, do we have a motion?
Mr. Chairman, in case number 2499, I move to deny the application of CH&N Materials for a variance from section 270-5.2.LL parentheses 19 of the zoning ordinance and to adopt as the decision of the zoning hearing board the 42 findings of fact, the 28 conclusions of law, and the order contained in the written decision presented at this meeting consisting of 10 pages, the order of which states as follows. Based upon the foregoing findings of fact and conclusions of law, the zoning hearing board of the Township of East Hempfield hereby denies the application of CH&N Materials for a variance from section 270-5.2.LL parentheses 19, which requires a 500-foot setback from all property lines to allow a 100-foot setback line from the municipal boundary separating East Hempfield Township from Manheim Township for a proposed mineral extraction use at the following two properties. One, the property identified as 929 Quarry Road, also identified by its Lancaster County Tax Identification Number 290-56451-0-0000, and two, the property without an assigned address identified by its Lancaster County Tax Identification Number 390-399-77-0-0000. Because the board denies the variance, the requested variance for an extension of time is denied as moot.
Do I have a second?
Second.
Any comments? Mr. Callis, how you vote?
In favor.
Mr. Kyle?
In favor.
And I will also vote in favor. The applicant's request for a variance has been denied. Does anybody have any comments? Next meeting is August 17th.
Yes.
And at this point, we don't know if there's going to be up till Friday, correct? Just in case, are you available? Jason,
Yes.
are you guys, gentlemen, available?
I'm available.
You are not. Make sure Mr. Luce is here. In that case, if there's no comments or questions, yes, ma'am. Okay, first of all, please go to the microphone and I need your name and address, please.
Okay, my name is Gwen Schuett, Gwenschut, at 692 Woodfield Drive in Lidditz. Does this mean with the denial, does that mean that they cannot have a quarry in that area? Or does that mean, I'm sorry, you answered my first question.
They cannot, at this point, they could have a quarry without the variance request. But it would only be like a 2.5 acre quarry, which financially probably would not make any sense. I don't know, I'm not in the quarry business, but I'm guessing that would make sense. Their only other option at this point is to reapply again for variance and try another track at how to get the variance approved.
Thank you very much.
You're welcome. Anybody else? And just to understand, this property is in the mineral extraction zone. And just to explain a little bit, that is a permitted use. They could go in as long as they met the 500-foot setback requirement and everything else that the township has in the zoning ordinance, they could extract minerals from that particular property. But like I said, it would only amount to about 2.5 acres. So I don't believe, like I said, I'm not in the quarry business, but I don't believe that's financially viable for them to do that. Any other questions? If not, this meeting is adjourned. Thank you.
Mhm.